Good afternoon, everybody, and welcome to this James Cooper's webinar on personal insolvency. My name is Andy Cowie. I'm the Marketing and Business Development Director here, and I'm joined today by Sandra Mundy, one of the partners within our business and one of our licensed insolvency practitioners. An apology to start off with. You may hear some background noise. We're having a slight issue with our air conditioning at the moment. Hopefully that will abate at some point, but apologies if it's winding you up too much. So the aim of today's webinar is to give you some information about the reasons why people get into financial difficulty and what can be done to help. I'm going to interview Sandra about the topic. However, if you do have any questions, please do feel free to post them in on the webinar, and Sandra will answer them at the end. Quick note that the usual disclaimers: this webinar is only a guide to personal insolvency and cannot be construed as advice. Should you have any specific issues you would like to discuss, then Sandra or one of the other of our team would be happy to talk to you after this presentation. So, Sandra, may I start with why, in your experience, people get into financial difficulty?
Well, Andy, there of course are very many reasons why people get into financial difficulties, but one of the more frequent ones that I encounter relate to self-employed people, either sole traders or partnerships, where they get into trouble with paying liabilities due to HM revenue and customs. I think this may be because, unlike paying a supplier where somebody receives an invoice and knows how much they've got to pay and when they've got to pay it, liabilities to HMRC, the taxpayer often calculates it themselves how much is owed, and then they report it and pay it. So for self-assessment, the payment only happens every 6 months, and for VAT quite often that is quarterly. There are therefore opportunities to either miscalculate or not provide enough, or be tempted to use funds to pay suppliers in the interim if things get a bit tight.
Okay, so are there any reasons why you see business people getting into financial difficulties?
Of course, there are a variety of reasons why people in business get into financial difficulties, and these can include things like suffering bad debts, downturn in trade, loss of market, an inability to be able to react quickly enough to changing market conditions, which may result in carrying significant overheads which the business can't afford. There could be a dispute resulting in legal action. So there's really quite a variety of reasons, and from time to time I see people that have run a limited company that's failed and left them with a number of personal guarantee liabilities which they're not in a position to be able to pay, because either they have no income anymore given the failure of their company, or their personal asset position doesn't support the payment of these liabilities. So really a whole host of reasons why people experience financial difficulties.
You mentioned quite a lot about businesses, which of course includes sole traders and partnerships getting into financial difficulties. But what about the general public, often referred to as consumers?
Yes, you're right to be concerned about consumers. There's quite a lot in the press recently about growing consumer debt, and indeed about a third of the adult population has less than £100 in savings. So it's not hard to see that if somebody gets ill, loses their job, or has a major life-changing event such as getting divorced, that they too can get into financial difficulty. Indeed, we may see more consumers getting into financial difficulties over the coming months and years, given increasing prices in shops, etc.
So how do people typically recognise that they've got a financial problem?
Well, quite often financial difficulties kind of creep up on people rather than being a catastrophic event such as loss of a job or loss of a contract. So the balance on a credit card will kind of often increase as less and less is being paid off each month. Bills will get paid later and later when funds permit. People start to struggle to pay their mortgage, for instance. This might result in mortgage arrears and overdraft terms are breached. So it's all the kind of things you'd expect to see, really.
What should people do if they think they have financial difficulties?
Well, I think the first step should always be to identify the extent of the problem and whether by a bit of careful budgeting someone can manage their finances and put themselves back on an even keel. Having done this, though, if there appears to be more than a short-term blip, then there are a number of options which they might look at, which might include raising some finance, selling some non-essential assets, agreeing payment terms with creditors and suppliers, agreeing a payment holiday on a mortgage instalment, that kind of thing, really.
Okay, so where can people turn to for help and advice?
The charity sector actually provides quite a lot of useful help and advice, especially in relation to consumer debt. So organisations such as the Citizens Advice Bureau, Step Change, the National Debt Helpline can be very useful. However, in my experience, if the debt relates to a trading position, either a sole trader or a partnership, for example, because these are typically much more complex matters, it's generally very useful to get some advice from an insolvency practitioner such as myself.
What sort of things will people be discussing at these meetings?
Well, initially the advisor will want to understand a bit about the background, what the person does, how much income they have, what their assets and liabilities are. What the advisor is seeking to establish is how much of a problem the person is in and therefore what might be appropriate to deal with that problem. The advisor will be looking to see if the individual is insolvent, in that either the person cannot pay their liabilities when they fall due or the value of their assets is less than the level of their liabilities.
So having established that there is a financial problem, what are the options open to that person?
Well, if, for example, someone is just struggling to pay their liability for self-assessment or VAT to HM Revenue and Customs, they might want to consider asking HMLC for a time to pay plan.
Are there any criteria that HMRC will apply before agreeing a payment plan?
Yes, HMRC, in my experience, always require the returns to be up to date, albeit that the tax may not be paid. And the agreement that the debt is repaid in full over a sensible time frame. So typically they're looking at something under 12 months. HMRC are unlikely to consider a time to pay arrangement for somebody that already has a failing time to pay arrangement or has a series of plans in the past. What they will want to be assured also is that there are not sufficient assets or funds available now to be able to pay the time to pay, the taxes due now. And repay the debt in full, and that the plan be put forward is fair, viable and feasible, really.
Okay, so if you're thinking about putting a plan to HMRC for time to pay, do you require someone to assist you with that?
No, it is something that you could do yourself, but it does involve a phone call or two to HMRC. However, if your situation is complex, for example, and you need to provide HMRC with trading plans and forecasts, it may be advisable to instruct your accountant or somebody like me to assist you.
So what happens if there's a more widespread problem than just a liability to HMRC?
Well, it really depends on the extent of the person's assets and liabilities as to what the options are available. So, for example, someone might consider a debt management plan to pay their debts in full over a period of time. A debt management plan is not a formal insolvency procedure and it's not legally binding on creditors. It doesn't usually enable a debt write-off, although in some instances it may do. However, it's normally possible to agree that no further interest is charged, for example. The administrator of that debt management plan will be regulated by the Financial Conduct Authority, and they will collect regular contributions from the debtor to make payments to the debtor's creditors. If a debt management provider from the charity sector is chosen, then the debtor rarely pays any fees associated with administering the plan, which obviously is good. If, however, a commercial operator is chosen, then the debtor will pay fees, and this could prolong the life of the debt management plan, as the fees will be deducted from the regular contributions that the debtor makes. A debt management plan is usually used where a debtor can afford to pay only a small amount to his creditors each month, or has a short-term financial problem where he'll be able to resume full payments within a few months if he just gets a little bit of breathing space. So where a debt management plan is being used to pay only a small amount each month, the debtor should take into consideration at the outset how long it will take to repay his creditors. So, for example, if a debtor could only afford to pay, say, £50 a month into a debt management plan and he owed his creditors, say, something in the region of £10,000 and there was no debt write-off, it could take him more than 16 years to repay his creditors.
So, Sandra, what do you see as the advantages and disadvantages of a debt management plan?
Well, I think a debt management plan can work really well where there's either a short-term blip, so for example, someone is between jobs just for a period of a few months and they can't afford to pay their creditors in that time. And putting in place a debt management plan does give them that breathing space that I was speaking about. And it will stop their creditors hassling them. I mean, I think poor guys sometimes get lots and lots of phone calls when they get in from work of an evening, which is just quite difficult to deal with. It will also work well where there's a repayment can be made within a reasonable time frame. So, for example, if they could repay their debts within a year or two. It's positive in that it is not a formal insolvency procedure and tends to have less of an impact on people's credit ratings and therefore their ability to borrow money in the future, for example, via a mortgage. But the major disadvantage, as I see it, is that it's not legally binding on creditors, and creditors may at any time decide to take action to bankrupt the individual, and therefore it cannot give complete peace of mind to the debtor.
So are there any procedures that give debtors more certainty?
Yes, there are a variety of other procedures that debtors can look at, for example, debt relief orders, administration orders, voluntary arrangements and bankruptcies.
Okay, sorry, forgive me, I've not heard about debt relief orders. What are they?
Well, a debt relief order is legally binding, but they're only available to debtors that owe less than £20,000, where they don't have a surplus income on a monthly basis and they don't own their own home. Once in place, creditors cannot recover their monies without the court's permission, and debtors are usually discharged from their debts after a period of 12 months. So in order to obtain a debt relief order, a debtor needs to apply through an authorised debt advisor, such as a charity like Step Change, and they only cost £90, so that's quite good. And sometimes the charity will even pay that on behalf of the debtor. So debt relief orders can be particularly useful for consumers that get into financial difficulties.
Okay, good. You spoke about administration orders. Are they any more flexible?
No, again, administration orders are used in very specific circumstances. So an administration order is a way for a debtor to deal with debt if they have a county court or high court judgment against them and they can't afford to pay it in full. The debt must be for less than £5,000, and the debtor would then make monthly payments to their local county court, and the court then divides up the monies between the debtor's creditors. The creditors that are listed on the administration order cannot then take any further action against the debtor without the court's permission.
So voluntary arrangements, they've got to be more flexible, haven't they?
Yes, you're right, they are. There are two types of personal voluntary arrangements. There is the individual voluntary arrangement, and then there's a partnership voluntary arrangement. So voluntary arrangements are legally binding agreements between the debtor and his creditors. The debtor will write a voluntary arrangement proposal to his creditors. Well, in reality, it's the insolvency practitioner that writes the proposal, but it explains how the liability arose and what he intends to do to repay his creditors, how much the creditors might expect to receive, and in what time frame. Creditors will review the voluntary arrangement proposal and decide whether it's something that they are willing to support. They might even think about putting forward some modifications so that it is more palatable to them. For a debtor to obtain a voluntary arrangement, he needs the support of at least 75% by value of the creditors that vote on the proposal. And once he's obtained agreement of those creditors, all the creditors are legally bound by that agreement. Normally a debtor would have to demonstrate to his creditors that by supporting a voluntary arrangement proposal that they're likely to receive a better return than if the debtor were made bankrupt. Creditors would also expect the arrangement to contain sanctions such as the right to bankrupt the debtor if the debtor does not fulfil his part of the bargain in the proposal. So a voluntary arrangement usually requires the debtor to pay contributions to the supervisor over a period of between, say, 3 and 5 years. Alternatively, sometimes an arrangement can be reached for a one-off payment. So, for example, a third party, maybe husband, wife, parent, for example, puts some money in, which then facilitates a much shorter period of arrangement.
Gotcha. So what would you see as the main advantages of voluntary arrangement?
Well, it is legally binding on the debtor's creditors. The debtor may not be required to pay his creditors in full and will be discharged from the liability at the end of the voluntary arrangement if he's complied with the terms. It usually gives the debtor more control over what happens to his assets. So, for example, it might be possible to agree that the debtor's home is excluded from the voluntary arrangement. Usually debt collection agencies stop hassling them after the voluntary arrangement is put in place as well.
Good.
And if the debtor runs his own business or acts as a company director, they're usually able to continue to trade, which is in stark contrast to bankruptcy. And there are some occupations, for example, accountants, police officers and certain public offices, where bankruptcy might result in the loss of employment. However, an employer or a professional body is usually willing to accept that the debtor continuing in employment while subject to a voluntary arrangement. So there's some significant advantage there.
So I'm guessing there's going to be some disadvantages associated with a voluntary arrangement too.
Yeah, right. It's not a panacea. So if the debtor does not or cannot comply with the terms of the voluntary arrangement, then the supervisor of the voluntary arrangement will usually have to take action that will result in the debtor being made bankrupt. So you could be sort of 4 years into a 5-year voluntary arrangement proposal and something goes wrong and still end up in bankruptcy. So that's not ideal. And if the voluntary arrangement proposals, when you put them to creditors, are not accepted, then it's likely that a creditor at some point in the near future would then petition for the bankruptcy of the debtor. So it's sort of a bit of an all or nothing situation. The debtor is normally asked to pay a fee as well at the outset to cover the cost of the advice and the preparation of the proposals and for the nominee to act. And if the creditors don't approve the voluntary arrangement proposal, then that fee is not usually refundable. So the duration of the voluntary arrangement is typically 3 to 5 years, as I sort of said, and it can be quite difficult to predict what might happen in that time frame. So if circumstances change, the debtor may not be able to continue to comply with the terms of the voluntary arrangement, and if it's not possible to vary that voluntary arrangement proposal, then the supervisor may end up bankrupting the debtor. And we were speaking about a matrimonial home earlier, and the debtor might well be able to exclude that from the arrangement, but creditors will want to see an amount which is equal to the equity in that property being introduced to the voluntary arrangement. So if the debtor can't either raise the finance or afford to pay the finance that he has raised, then he could still lose his home. And for debtors that rent homes, then the tenancy could be terminated if the debtor enters into a voluntary arrangement as part of the terms of the tenancy agreement. But I don't think that happens very often, and indeed I've never seen it happen where rental payments are up to date. There is a central register of voluntary arrangements that can be searched by anyone. The debtor's credit rating is therefore likely to be affected for some 6 years as potential creditors or potential financiers of the debtor will be able to find out that they are in a voluntary arrangement or have been in a voluntary arrangement. So that continues even after the voluntary arrangement has been successfully concluded. The debtor, one sort of final point really, the debtor cannot act as a trustee of a charity whilst he's subject to a voluntary arrangement, and if the debtor inherits or benefits from any windfall during the period of his voluntary arrangement, then normally the supervisor will claim that for the benefit of the creditors.
Okay, thank you. The cost of putting a voluntary arrangement in place?
Okay, well there are a series of costs typically associated with initially the advice, the preparation of the proposal, and then acting as nominee and ultimately the supervisor. So the initial advice should be free, and then there may be some charge if there's further advice required in a more complex situation. Preparing the proposal should cost in the region of £2,000 to £3,000, and acting as nominee possibly in the region of £1,500. The cost of the supervisor will depend on what the supervisor has to do during the course of the voluntary arrangement.
A little while ago, Sandra, you mentioned a partnership voluntary arrangement. What's special about partnership?
Well, if 2 or more people are in partnership together and it's not part of a limited liability partnership, then they are individually responsible for the liabilities of the partnership. Sometimes I find that people don't even realise they're in partnership, which might sound a bit of an interesting concept. But for example, a husband and wife that run a pub, it might be seen as the husband's business, but in some circumstances the wife exercises a significant degree of control, and then it could be argued that she and he are in partnership together. So if a partnership gets into financial difficulties, then the creditors may look to any one of the partners to settle the liability. Creditors will typically pick the partner that has the most amount of assets to pursue. and that partner will have the obligation to pay the creditor, and then will have the option to seek redress from his fellow partners. However, if his fellow partners don't have any funds with which to pay him, then he may well be out of pocket. The partnership voluntary arrangement deals with the assets and liabilities of the partnership, but not of the individual. So quite often what you'll see is that when a partnership gets into difficulties, not only will you have a partnership voluntary arrangement, but also the individual partners will either need individual voluntary arrangements or bankruptcy to resolve their financial difficulties too.
Thank you. Okay, shall we move on to bankruptcy?
Yep. Bankruptcy is a procedure that is used where a debtor cannot pay back his debts in a reasonable time frame. The debtor can either petition for his own bankruptcy, or a creditor may petition for his bankruptcy. Once a debtor is declared bankrupt, then a trustee in bankruptcy is appointed, and they will realise the debtor's assets for the benefit of his creditors. So the debtor may also be required to make payments from his surplus income on a monthly basis to the trustee in bankruptcy for a period of 3 years, albeit that the bankruptcy itself only lasts for 12 months. And at the end of the bankruptcy, the debtor is then released from his financial obligations to his creditors.
So if somebody wanted to petition for their own bankruptcy, how much would that cost?
Well, would you believe it? These days, a debtor can apply for bankruptcy online, and the cost of that application is £680. However, if a creditor is going to make an individual bankrupt, then the cost is somewhat higher. There's a petitioning deposit of £990 and court fees of £280, and usually the creditor will incur some legal costs in making someone bankrupt.
So again, what would be the main advantages of bankruptcy?
Well, once a debtor is discharged from bankruptcy, it releases him from almost all of his debts that were present at the date of the bankruptcy order. So there are a few debts that might not be released, and they're things such as student loans, matrimonial debts, fines and gambling debts. Creditors and there are a few other advantages. So creditors and debt collection agencies following a bankruptcy will normally deal with the trustee in bankruptcy and will stop contacting the debtor and hassling them shortly after the bankruptcy is put in place. And in most instances, a debtor will receive a discharge from bankruptcy within 12 months. The debtor can only be asked to contribute surplus income for a maximum period of 3 years, whereas in a voluntary arrangement, sometimes it may be as much as 5 years.
Okay, and the disadvantages?
Well, the main disadvantages are that the bankrupt's residential property will form part of the bankruptcy estate, assuming, of course, that that's an owned property. The trustee will also claim other assets that are not required for basic domestic living or for the benefit or for his trade for the benefit of the creditors. A trustee in bankruptcy cannot realise the residential property that I was talking about for a period of a year if either the bankrupt's co-owning spouse or his children reside at the property. Usually, if the bankrupt's property is jointly owned, the bankrupt's spouse will be offered the opportunity to acquire the equity interest in that property. And it's possible that the trustee in bankruptcy will allow some deduction for the value of the equity if the spouse is purchasing the property, as this kind of takes into account the fact that the trustee in bankruptcy will not need to obtain an order for possession and sale, and therefore associated costs with doing so. And there will be no estate agency costs, etc., to be paid from the sale proceeds.
So what about other assets? I don't know, a car, for example?
Well, if the bankrupt owns his own car, which is rare these days, I know, he doesn't require it either for basic domestic living or to derive an income, then the car will be sold for the benefit of his creditors. In some instances, for example, where the debtor has a luxury car and does not require that during his but he does require some transport during his bankruptcy, then the trustee in bankruptcy may sell that luxury car and provide the debtor with sufficient funds to buy a more modest vehicle. But more and more often we find that people have cars on finance. Very few people necessarily go out and buy and own them outright. So if the bankrupt needs the car for either the basic domestic living or to trade, then provided that the finance costs can be met from the bankrupt's income, then he may be able to retain the car. However, there may well be provisions in the finance agreements, and certainly if the debtor falls behind in payments on the finance agreements, then the financier is likely to recover the car in the event of the bankruptcy. And in this case, the car will maybe be repossessed and the bankrupt left without any transport.
So what about other things that the bankrupt might own?
Well, the trustee in bankruptcy has an obligation to realise assets for the benefits of the creditors, and this will include savings or investments that the bankrupt might have, such as premium bonds, ISAs, and things like stocks and shares. The debtor's bank account will also be frozen on bankruptcy, and any funds there transferred to the trustee in bankruptcy for the benefit of creditors. So going forward, the debtor is only likely to be able to operate a basic bank account during the period of his bankruptcy.
Okay. Is there any impact on the debtor's credit rating going forward?
Yes, bankruptcy again is filed at a central register which can be searched by anyone, and the debtor's credit rating will be affected for at least 6 years. Whilst the bankrupt is in bankruptcy, he can only obtain credit of £500 without informing the lender of his bankruptcy. And the bankrupt cannot, without leave of the court, act as a director of a company or be involved in the management, formation or promotion of a limited company. And if the bankrupt is self-employed, his business will normally be closed down and employees dismissed by the official receiver. A bankrupt cannot trade in a name other than which he was adjudged bankrupt. So there's quite some impact there on his ability to earn going forward. And there may also be an impact on the bankrupt's earning potential if he's, for example, an accountant, a police officer, or holds certain public offices. And as with a voluntary arrangement, he can't act as a trustee of a charity whilst he's bankrupt.
I've heard that pensions can be affected by bankruptcy. Is that the case, Sandra?
A trustee in bankruptcy cannot attack the pension unless there have been excessive pension contributions. There's been sort of various wranglings in this in the courts over a number of years. But if someone is at an age where they can draw a lump sum or an income from a pension but have not already done so, a trustee in bankruptcy cannot force a debtor to either draw that lump sum or take an income during the period of his bankruptcy. But if the debtor's already done so prior to his bankruptcy or decides to do so during his bankruptcy, then the lump sum or any income coming from the pension, the trustee can take the proceeds in those circumstances. And if a bankrupt inherited or benefits from any windfall during the period of his bankruptcy, then the trustee will also be entitled to claim that for the benefit of the bankrupt's creditors.
So what about the stigma associated with bankruptcy?
Well, some time ago people used to be very concerned about the stigma of bankruptcy. I think that may hark back to the Victorian era with debtors' prisons, etc. But I think that the stigma of bankruptcy is somewhat reduced these days, and indeed some very high-profile people have been made bankrupt and gone on to be very successful in their chosen fields.
Sandra, we've spoken a lot about what debtors might do when they get into financial difficulties, but how do suppliers protect themselves from the failure of an individual?
Well, that's an interesting question, Andy. Unlike limited companies, there is no requirement for individuals in business to publish accounts, and therefore the sources of financial information can be somewhat restricted. It may be possible to undertake a credit scoring exercise for an individual prior to advancing credit to them. And indeed, if you have concerns, you may consider whether you actually advance any credit at all, or if you want to take a personal guarantee of somebody else, for example. Landlords might want to take the personal guarantee of a parent of a young person where that person's either a student with a restricted income or has a low-paid job. Basically, when extending credit to individuals, sole traders or partnership, I suggest that you do it with care and that a lot of research is done if you have any concerns.
Well, thank you, Sandra, for that quick canter through personal insolvency. I've certainly learned a thing or two along the way, and I hope those people on the webinar have too. If you are interested in personal insolvency, you can find further information on our website, details on the screen, and also the insolvency services have some very informative guides on their website, and details can also be found on the screen. Alternatively, I feel sure that Sandra would be delighted to speak to you in more detail following this webinar, should you like to contact her directly. I will open up the floor for any questions at this point and give you a couple of seconds just to put something through. Nope, obviously we've managed to answer all the questions that are there, so I will take this opportunity to thank Sandra for that presentation, and indeed thank everybody for joining this presentation. We hope to get to present to you at a webinar again soon. Thank you very much for your time.
Thank you, goodbye.